Hello, I'm Dave Steinfeld, the owner of the law office of David Steinfeld in Palm Beach Gardens and a board-certified business litigation attorney here in Florida. The video you're about to watch is part one of a presentation I gave on electronic discovery and how businesses can prepare today for the challenges in this area they will face tomorrow. This video describes my background in the area and where in a business dispute electronic discovery resides. This video is not intended to provide legal advice, but merely to educate you on electronic discovery and the challenges of electronic information management that all businesses in Florida now face. For your specific and unique legal needs, please contact me for a private consultation. My contact information is on my website at davidsteinfeld.com. Thanks for watching. Thank you all for coming today. The topic of today's presentation is electronic discovery and what businesses can do now to prepare for the coming age of electronic discovery, which is upon us. As of September 1st, 2012, in Florida state courts, we now have authorized the discovery of electronic information such as emails and other data that businesses store. And because most businesses store data electronically to some regard, the planning that's going to be required of how they manage this data is now becoming critically important for them. In this first video, I'm going to tell you my background and where within the scheme of a business dispute e-discovery resides. And then I'm going to tell you specifically in the next video what electronic discovery is and then what businesses can do to guard against future potential sanctions or electronic discovery costs. I am a Florida Bar Board Certified Business Litigation Attorney. I am one of just over 200 out of almost 100,000 attorneys in the state now that has that expertise and certification. I am also AV preeminent peer review rated, which is the highest peer review rating by Martindale-Hubbell that any attorney can receive. I am a member of the fellow of the Litigation Council of America, which is an invite-only litigation honor society. I was named 2012 Florida's Legal Elite, and I am also a member of several organizations that are dedicated to electronic discovery, and that's how I stay current on all the case law and information and technology in the electronic discovery realm. My practice is business litigation and consulting with businesses on how to avoid litigation and how to avoid the problems that come out of disputes with some prior planning and advanced logistics and planning. A business dispute can be broken down very simply into a few components. There's basically three large parts, simple parts to a business dispute. There's a beginning, there's a middle, and there's an end. In the beginning phase, which is what we call the pleadings phase, that's where the parties present their information in writing in a lawsuit to the court and to each other to tell the parties and the court and everyone involved in the process what is the basis of their claims, what is their complaint, what are the issues, what are the facts that they see. There can be some motion practice in that phase, back and forth, and I have an additional video on my website entitled Phases of a Lawsuit that goes into greater detail on this, but I'm giving you a thumbnail sketch now of these phases. The middle phase of a business dispute is what we call the discovery phase. Unlike a criminal case where the prosecutor would gather information and then bring charges, a civil case or commercial case operates in the opposite manner to a great extent, where a business or a business person may know that something has happened, there's been some sort of a breach of contract or something, but they don't know the exact or precise specifics, or they have to get information from the other side or from a third party. So that is what the discovery phase is designed to do. It allows the parties, through various mechanisms, to go out and gather information. This phase of a dispute is often where most of the costs are incurred, because this is where a bulk of the work is incurred, and this is where you would see things like depositions that everyone is familiar with. The third phase of a business dispute is what I would term the end phase. Somehow the dispute itself must come to a close. That could be from a settlement, through a mediation. That could be through an actual trial. It could be through other procedural mechanisms that are utilized under the rules of procedure. But at some point, that process ends. Now, unfortunately, it doesn't always terminate and completely end. You actually have an afterword, and that could be things like an appeal. That could be enforcement of a judgment. It could be an enforcement of a settlement. And just like the afterword, you also have the before. You have things that happen before the lawsuit. That's where planning for electronic discovery and electronic information management can greatly benefit a business, because it reduces the future costs in the discovery phase in the lawsuit, and it reduces the possibility that businesses can be exposed to sanctions or penalties for not properly maintaining their electronic data. This is now becoming critically important, not just because Florida has updated its civil rules of procedure to allow for the discovery of electronic data, but because almost every business and operation in our state today is storing data electronically in some regard.